Good morning, everyone. Dave KUBIKIAN from the Herzog law firm here. Welcome to a smaller version of our webinar week. Today is the first webinar we're doing in a series of 3. Today's topic is wills versus trusts. And before we get into that, let me tell you a little bit about our firm. So Herzog Law Firm has been around for about 77 years now, and we primarily specialize in estate planning and elder law. We have 4 offices, and you can see at the bottom of your screen there, Albany, where I am right now. Looks very nice outside. Clifton Park, Saratoga Springs, and then down in Kingston, but really we serve all of New York State. We have clients in Long Island, we have clients out in Buffalo, and everywhere in between. We started doing these webinars because of COVID, and we kept doing them because we've gotten a lot of people who get to listen to us from their own homes, their own kitchens, and all that stuff. It's a nice way to learn. It's a nice way to be able to shut it off if you don't want to hear anymore and you're not in a room awkwardly walking out, which is nice as well for me. The negative is that we used to be in all these hotel conference rooms, and I have a ranking system for the chocolate chip cookies in various hotels, and I don't get to eat them as frequently as I used to. So that's about it. All right, enough of that. So the topic is wills versus trust. The idea is we're going to talk about these 2 very important documents. In many cases, you should have both of them, but as you'll see, there's a progression in how estate plans work. So I guess we should start talking about what an estate plan is. An estate plan is who gets what one day when you're not around. That's like the literal definition. You don't have an estate until you're no longer alive. Planning for who gets it is, well, that's an estate plan. But in my profession, it ends up being a lot more than just that question. It deals with incapacity while we're still alive. A lot of it gets into this area of elder law, which is how much money can we protect? How are we going to get our long-term care needs to be taken care of without spending through all of our money? To answer the question, who should have an estate plan, the answer is kind of everyone 18 or over, even if that 18-year-old just has 1 or 2 really super basic documents like we'll talk about, because the fear is not just death, although that's possible. It's also being incapacitated or disabled temporarily or permanently at some point in our lives. A lot of what we talk about is about planning in case something happens, because the alternative to not planning is even worse, right? Bad things are going to happen regardless of whether you plan for it. So if you don't have a power of attorney, as an example, which is the first document we're going to tackle, I might need to do something called the guardianship, which results in almost the same thing, which is someone else can do things for you, except we just lost about $15,000 as part of that process. So let's avoid guardianships out there. As we get older, as our families grow, and then eventually families shrink, the estate plan changes and morphs into different versions of itself because we're concerned with different things as we get older. Excuse me. Your most basic estate plan consists of 3 or 4 documents. It's a power of attorney, it's a healthcare proxy, which at our law firm we couple with a living will, and then it's an actual will, a last will and testament. This is like as basic as you get. What's a power of attorney? Well, it's a document that you do during your life. It's effective during your life. It ends at the end of your life. When you die, your power of attorney is over, okay? You're picking people who can sign for you, who can act for you, who can transact for you. If you are unable to do so yourself, you're unavailable, you're sick, you're stuck in bed, you're permanently incapacitated because of dementia, you're stuck in Europe because you can't get a flight back. I don't know. If you want someone to be able to sign for you, you need to do a power of attorney. A lot of times we have married couples who say, well, wait a minute, I can sign for my husband, he can sign for me. And I say, nope, no, you can't. Well, we each can sign the check on our checkbook. Yeah, that's great. Well, it's because both of your names are on the checking account. It's not because you're signing for each other. So if you want that ability, and it is really important to have this kind of ability, you do a power of attorney. Now, there's 2 sets of powers in the power of attorney. There's kind of like the handle my affairs, pay my bills kind of powers that we normally think about. And then there's other powers that get into gifting transactions. I have the pain look on my face because New York uses the word gifting. and it confuses people and it kind of freaks people out, to be honest with you. So stage one of power of attorney is I need someone to be able to pay my bills, handle my bank account, handle my life if I'm unable to. Part two is I need someone who can proactively plan or last second plan to save as much money as possible. I need someone who can make lemonade out of lemons. And a lot of times that involves creating trusts, like we'll talk about later on, or other kinds of transactions that may technically be considered to be not arm's length, i.e. a gift. It's not someone taking your money. On the flip side of the power of attorney, the first cousin of the power of attorney is the healthcare proxy. Same story, same idea. We're picking people who can do things for us when we are unable to. It's effective during our life. Our healthcare, I guess, doesn't matter one day when we're dead. So you're picking someone on a sunny day for the rainy day. This person can speak to the doctors for you. They can make decisions about non-end of life care, or at least that's what the healthcare proxy does. The end of life situations or potential end of life situations, that's where the living will comes in. And as I mentioned in our office, we do 2-in-1, these two documents as one. And when it comes to the living will, our default provision is, look, if I am incurably and irreversibly going to die really, really soon, and I'm unable to communicate myself about my wishes are not to be propped up, not to be operated on, poked and prodded. Again, if I am incurably and irreversibly about to go somewhere else. Okay. So it's not like if I'm choking on a steak, don't try to get the steak out of me. It's resuscitate me, get me better if I can get better. But if the writing's on the wall, nothing's going to change. I'm not going to be reading stories to my grandkids because I'm that incapacitated while being in the dying process. Let me go. Wow, things got really dark really fast. I apologize, but that's what happens when we start with powers of attorney and healthcare proxies. It'll get a little better as we go, but not a ton, because now we're going to talk about a will. Okay, so everyone out there should have a will, but a will is not usually where we stop because it accomplishes far less than you think, and in some cases, it accomplishes far more. Well, what's a will? A will is a document that says where your assets are going to go when you pass away. There are different kinds of wills that have these broad labels to them. A simple will, don't let the name fool you, can be an unbelievably complicated document with 20, 30 pages of who gets what and how do they get it and when do they get it. But I guess the easiest way to describe what a simple will is, the final destination for your monies is described in that will, as opposed to something called a pour over will. We do pour over wills when we do a trust for a client. And that pour over will says, I give everything to my trust. It pours in to the trust. If the trust was a big bowl, we're pouring the will into the trust. So the beneficiary of your will there is the trust. It's a pour over will. Bypass wills are something we use a little more frequently when we're worried about estate taxes. For this, now you got to have some serious moolah to be talking about estate taxes these days. As a married couple, we're talking, between $6.5 to $13 million in New York, or upwards of $24 million federally. So still is an appropriate plan for those that need it. Now, I will say a lot of the people who would do a bypass will end up doing trusts as part of it, not because they have so much money, but because we want to avoid probate. Your will, regardless of the type, has a bunch of different important people. There's an executor of the will. That's the person who makes sure that whatever the will says happens. They follow your instructions. There's beneficiaries, those people or those places, those great causes that may be getting money as a result of your decisions in the will. And your will has to go through a process called probate. And people always say, what is probate? I thought a will avoids probate. No, a will has to go through probate. Probate is the proving of the will. The reality is that your will is just a piece of paper until two things happen. Number one, you got to die. I'm sorry. Number two, that piece of paper that says will, that was signed by you, that was witnessed by two people, it needs to be submitted to your county's surrogate court, along with a bunch of other documents and something called a probate petition. And the job of the court is not to look at whether what you did was a good idea. Their job is to say, hey, did Mary have the right capacity when she signed this? Were there two disinterested witnesses? Was there a figurative gun held to her head? Mom, I'm not going to take care of you unless you leave everything to me. Did mom know what she was doing? Did she have her mental capacity? Did she have the ability to understand the natural objects of her bounty, et cetera, et cetera? Part of the probate process involves us tracking down people who would get more money from your estate if you didn't have a will. So if I, for example, left everything to St. Jude's Hospital, a wonderful children's hospital, and that's what my will said, the people who could contest my will would be my wife and my children. Why? Well, because if I didn't have a will, everything would go to my wife and my children. This, you keep working on this, and if you're deciding to not treat your kids all the same, if you're deciding to leave someone out of your plan and they otherwise would have gotten something from your estate if not for the will, it's a very awkward situation where we are actually asking people. One of the documents we submit to the court is a waiver from that person, waiving their right to contest your will. What a conversation. Do you mind waiving this thing because you got less money than New York State would have otherwise given you? You make more money if you can contest this. Do you want to waive? Sometimes people just don't want to sign something sent by an attorney. They don't want to sign anything. They don't want to talk to an attorney and pay an attorney to look at it. And that just creates unnecessary delay. And every delay, every court appearance is money, 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 money. And so probate is pretty awful because number one, it takes time, usually about a year, although we have ones going on for 3, 4, 5 years. But also it's unnecessarily expensive. Filing fees to get into the court are as high as $1,250 just to get in before the attorneys are involved. All that being said, I'd rather have you have a will than nothing, okay? I'd also prefer that you not die anytime soon. There are a couple of execution requirements for your will. I mentioned the capacity to sign 2 disinterested witnesses. Every now and then we have clients who got a will online and they had their kids be the witnesses to the will, or other people who are interested parties, and that can affect whether or not the will be admitted for probate, whether it will be accepted. Sometimes people say, you know what, I don't like that provision in my will from 10 years ago. I'm just going to cross it out. I'm going to scribble a new name or a new dollar amount for that person. Those changes are not accepted, and it could actually impact the validity of the entire document, even if you just cross out a small section. So you got to be careful. A bunch of other requirements that I won't get into. If you don't have a will, I actually had someone say this to me yesterday. They said, well, you got to have a will because if you don't, the state will get everything. No, that's not what happens. New York has a law that says exactly what's going to happen to your money if you die without a will. That's called dying intestate. So it's the intestacy laws. And those laws say, for example, if you look at that second bullet point, if we're survived by a spouse and no children, everything goes to your spouse. We're survived by children and no spouse, everything goes to your kids. So far, it makes a lot of sense. That first bullet point is where we start to run into some problems, because if we are survived by a spouse and children, I'm married and have 2 kids and they're little. Under New York law, everything would go to my wife. Well, no, 1/2 or so, 50,000 plus 1/2 goes to surviving spouse. The other half goes to kids. And if they're 3 and 9, like my kids are, well, as soon as they turn 18, they're going to get a lot of money, potentially, because even if it's not a lot of money to get right now, it's going to be held for my 3-year-old another 15 years, growing and growing, hopefully. And it'll affect their college eligibility for financial aid. It'll affect their decision-making on whether they think they need to go to college, because they may think $100,000 is a lot of money, which it is, but it also isn't. So we have a lot of unnecessary problems. Plus the probate process is grueling because my kids are kids and they will need a guardian to represent their interests in that proceeding. But it can get worse, which is that bottom bullet point. So we don't have a spouse, we don't have kids. Actually, everything goes up to mom and dad. And if mom or dad is in a nursing home, it doesn't matter. They'll still inherit from us. We get one of those once or twice a year where our client in a nursing home where we did everything right just inherits from one of their kids who died spouseless, childless, and will-less. No parents, it goes to siblings. No siblings, nephews and nieces, great nephews and nieces. None of that. We go maternal, paternal, grandparents, uncles and aunts, first cousins, and et cetera, et cetera. So it's usually uncommon that the government will ever get money if you don't have a will. It's far more likely that someone you don't want to get your money gets your money by not having a will. We are pro plan at Herzog Law Firm. So whatever it takes for you to have a plan, whether it's a will or a trust that we're about to talk about, sounds good to us as long as it reflects your wishes. Now, your will is not in charge of everything. And this is where we start talking on both sides of our mouth, right? On one end, wills are great because it provides a plan. On another end, we don't want wills, so we don't want to go through probate. Well, the reality is that for a lot of people, most of their assets are non-probate assets. And I'm talking to at least all the married people out there, if not everyone. So a will is in charge of those assets that you die with where there's no co-owner with rights of survivorship and or where there's no beneficiary on an account. So I'll use myself as an example so nobody feels bad. If I died right now during this Zoom under suspicious circumstances, I would suppose, given that, I just had a sip of my coffee and who knows what was put into it, we probably don't have to go through probate at all. And the reason why is because my house is joint with my wife, my bank account's joint with my wife, my retirement has her as a beneficiary, my life insurance has beneficiaries on it. So none of my assets would go through probate unless we're going to sue somebody for something that happened, right? Maybe a lawsuit associated with my death, highly unlikely. If my wife then gets called and she learns that I've died again at one of my webinars and she, oh my goodness, and she has a heart attack and passes, God forbid, we're going to obviously probate her will because she didn't die with a co-owner on the house, right? I predeceased her. In that case, her will becomes really important to make sure that money goes to the kids with certain rules and ages so they don't get it all at 18 years old. Now, here's a little nuanced point that I want to make clear. Your will, which everyone should have, is only in charge of the assets that pass through the will. So if you're sitting there and you say, well, you know what, I did a really nice will that leaves things to my kids, but at certain ages, I don't want them to spend all the money at 20 years old. Well, we then got to make sure that your money actually goes to where the rules are. So for example, I mentioned I have a 9-year-old and a 3-year-old. I'm going to ask someone to unmute themselves, whoever. Brian, unmute yourself for a second. I got a 3-year-old and a 9-year-old. Okay, I have life insurance. My wife is my beneficiary. Who's my backup beneficiary on my life insurance? What do you think?
I don't know. I'm waiting for the answer.
All right, well, I'll tell you. A lot of people would say my kids, right? Of course, I want my life insurance to go to my kids, right? Well, no, I can't name my kids on my life insurance because they're 9 and they're 3, right? And if God forbid something, date night went wrong, and now there's a bunch of money in a life insurance policy going to them, that money isn't governed by the rules in my will. That money went like that to them. It avoided probate. It was non-probate property. So we do this weird thing where I say, oh my God, you got to avoid probate, avoid probate, avoid probate. But then I say to people who have little kids, where I don't think a trust is yet appropriate for them just because they're so young, relatively speaking, right? I say, okay, well, once you're done with your will, go call your life insurance broker and change your backup beneficiary. So for me, right, my wife would be my primary beneficiary. My backup would be the estate of Dave KUBIKIAN. So it goes to my will. Instead of running away from probate, I'm running to probate to make sure that those rules, those very valuable rules in my documents, govern as much money as possible, because those rules are only in effect if my wife predeceased me, right? So for certain times, we want to actually point things to the will. We want to use the language. There's a better way to do it, though, where we can have rules on our money while avoiding probate. And that's the last bullet point on the list there, which is trusts. So we're going to spend the second half of the program now talking about trust. But before we do, let me just ask, does anyone have any questions about wills? All right. You guys are either asleep or confused or actually don't have questions. So I'll take any.
I do. I have a question.
Yes, sir.
I do. What happens if your executor takes a job with a brokerage firm and his brokerage firm says you're not allowed to be an executor? Or what happens if your executor becomes incapacitated and you haven't changed your will?
Sure. So here's the good news. And I'm not going to be a wise guy about it. If you are still alive, okay, if you're still alive, then your executor is not your executor. Your executor only becomes officially your executor when you're dead and that will went through probate. Okay. So if something happens during your life, you could always change your will. Besides that, your will should have a backup executor, maybe a backup to the backup. Okay. Just in case. Now, let's say you passed. Okay. And it turns out that there's a lot of money in your estate that needs to be managed. And because it's a financial advisor, they can't manage it. They're being told they can't do it. Well, at that point, they could resign and your backup could then be elevated to serve. If your executor during the administration of an estate dies, that happens, unfortunately, more often than you think. Someone else can take over. If there's no one, well, then there's actually laws that say who has priority from a family perspective to serve as administrator of your estate. So there's a solution to everything. I like backups on stuff. And if you're certainly alive, then your executor is not your executor yet. They have no power because that will is a meaningless piece of paper until you die and we go through probate. Okay.
Second question. This is a real example relating to executors. My oldest cousin passed away 2 years ago, and he lived in Michigan. His cousin on his mom's side showed up with a will that's 11 years old, never signed. And the lawyer that had drafted it retired, moved to Florida. And so she got a affidavit from the lawyer that he never paid the bill for his will, and he never confirmed those were his choices, but he did draft the will 11 years ago.
Yep.
She then claimed, since she was the closest living relative, that she was the executor and started handling the duties of being executor. And I tried to get an attorney to challenge that. It never did get challenged in court. What's the normal thing that happens when you want to challenge a relative of yours who has an executor you think should not be executor?
You fight it out in surrogates court, and we're lucky in New York. I don't know how Michigan operates, but in New York, the court does a lot of the vetting for you. So that's part of the reason why probate's such a pain in the, is that the court's going to say, all right, who's this? There's an unsigned will? I don't think so, right? We're going to have to submit affidavits saying that this was in fact the wish, because the court's going to say, look, if it was the wish, why didn't they sign the will? And can the attorney remember there was a signed will? If it's presumed to be lost, well, is it lost because somebody tore it up? Is somebody being the person who died? Is it lost because it's just lost? So there are circumstances out there where we've had, only one witness on a will where the will's gotten in. We've had situations where we can't find the original and the will's gotten in. But those are definitely not commonplace. And if there's a fight about it, it's even harder to get them in, right? We have had situations, everyone agrees, hey, we just can't, the attorney retired, we just can't find the will, that kind of thing. All right, good questions though. Let's move on to trusts, guys, okay? So what's a trust? And we've kind of been dancing around the idea of a trust already, because most of the wills that I do have trusts inside of them, okay? A trust is just a set of rules on money, okay? A set of rules on money. There's two main kinds of trusts out there. One is called a testamentary trust. The other one's called a living trust or an inter vivos trust, okay? A testamentary trust is a trust that is created in your last will and testament. Thus, it's a testamentary trust. That's the stuff I'd have in my will about my kids. That's the stuff some of you may have about grandkids. If any grandkid gets money, hold it until a certain age. Testamentary trust. That's it, just a couple sentences. Okay. It could last for a very long time. The negative on a testamentary trust is obviously you got to die first before it matters. And the will has to go through probate in order for the language in the will to take effect. Okay. And now the court's got its nose in our business going forward when it comes to this trusts administration. So obviously, if we know we're going to die, we don't want to rely on probate and testamentary trust, but it's better than nothing for sure. The kind of trust we do more frequently with proactive is going to be a living trust, something you create today. And let's just think about it like a box you create today. The rules as to how you could put something in the box or take something out of the box is going to determine whether your trust is a revocable trust or a irrevocable trust. So what's a revocable trust? So first of all, trusts, living trusts have parties. They have, instead of an executor, like there is in a will, there's a trustee in a trust. Still have beneficiaries, although we have beneficiaries during the life of the trust or during the grantor's life, during your life. You create a trust today, you put your house in it, that house is still going to be at your fingertips. It's still kind of yours, right? If you put stocks in a trust today, we want you to be the income beneficiary of the stock of the trust, right? You're still getting your dividends. There's also a death beneficiary, just like a will would. So inside every revocable or irrevocable trust is a really good estate plan. Just like the language in your will said all those different things. If this happens to this, all of that, pick it up. You could insert it in a revocable trust. You could insert it into a irrevocable trust. The trusts need a creator. That's you. And sometimes we're calling you a grantor, or we're calling you a settlor of the trust, and you're creating this thing. You have certain rights as a creator, right? If you have the right to remove something by yourself from the trust, then that trust is revocable because you, the creator, can remove something from the trust by yourself. The main focus of revocable trusts is couplefold, actually a pretty broad range. So sometimes people do revocable trust because they really just want to avoid probate. They have a pretty basic fact pattern, but they are so, maybe they had a bad experience in the family with someone else's probate. I don't want to do that to my nieces. I don't want to do that to my kids. I'm going to avoid probate. Great reason to do a trust, fine. Sometimes people have second relationships, third relationships, kids from a prior relationship, and it's complicated, right? But I want to make sure that my second spouse is taken care of. I want to make sure my kids from my prior marriage are taken care of. I want to make sure her kids are taken care of as well, but not as much as mine, blah, 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 blah. We can guarantee certain results by doing trusts. Because think about it, I can't do the old school wills in that kind of fact pattern, because if I leave everything outright, I give everything to my wife, my then wife, right? Don't tell my current wife about my then wife, by the way. So I leave everything to my then wife. Well, she may decide she doesn't like my kids anymore, because if she survives me, it's now her money. So I need to put rules on things to make sure my kids are getting something. So sometimes we'll use revocable trust there. Another time we use it is when people have estate tax issues, where we're going to use revocable trusts to take advantage of the different tax rules out there. I will bore you to death if I get into it right now, so we'll skip it. But it's sometimes it's because you have a lot of money you're doing a trust. Sometimes it's just because we have a house and we want to avoid probate, and we're doing a revocable trust. The one thing a revocable trust does not do is it does not help us when it comes to our long-term care needs. Okay. And that's where the next trust is going to kind of attack. So Medicaid asset protection trusts are probably the trust we do most frequently. It's a trust that is a grantor trust. You create it. It's for you during your life. If you put your house into it, you're still paying the bills and living in your house. You're still getting the star exemption. You could change it. You could change your mind as to who your beneficiaries are. You could fire your trustees and remove them. Okay. With Medicaid trusts, the goal is not just avoiding probate and not just leaving money to the right people the right way, like the revocable trust did and like the will did, except for the probate part. The goal of the Medicaid trust is to also help pay for long-term care expenses. The vast majority of our estates and our clients don't have a lot of drama. There isn't some big fight in court about who gets what. There is no reading of the will. There is no, children and spouse and, paramour who are all in the room and who gets what. Like none of that stuff happens. All right. I've never read a will out loud before in my life. The big threat to most estate plans isn't a fight. It's not even probate. The big threat to an estate plan is not how money is going to be split. It's going to be how much money is left. How big is the pie by the time we pass? Because at some point after we retire, as we continue to get older, there's this thing called long-term care that creeps in. And sometimes it takes the form of dementia or Alzheimer's. Sometimes it takes the form of Parkinson's. Sometimes it takes the form of my knees don't work anymore and I have trouble getting across the room. But that part of life is extremely expensive. And like nursing homes are $15,000, $16,000 a month. All right, well, I don't want nursing homes. I want to be at home. All right, pay someone $25 an hour for 10 hours a day and tell me how much money that costs at the end of a month, right? It's $250 a day. So you're looking at, $7,500 a month. And that's just 10 hours a day. So if we continue to be alive, which I hope we will have to deal with this issue eventually. Everyone's living longer and the issue is not going away. Okay. How you pay for that when you are retired on a fixed income is you're going to start getting into your assets. And the idea is, well, if there's some other payor out there, well, we'd like to take advantage of that. And there is. Medicaid. Medicaid is a really, really big program out there. And people say, oh, well, Medicaid is health insurance for people that don't have money. Yes, it is. But it is also a way to pay for long-term care expenses. Medicaid has two parts to it. They have a nursing home part where there's a 5-year look back period. You have to plan ahead of time if you want to protect your assets when it comes to nursing homes. And then there is a home care program called Community Medicaid. We have a whole webinar on it tomorrow at 2 called Aging in Place. Watch it. For Community Medicaid, there is currently no look back period. I could get any one of you guys if you had the need, and we had the logistics to do this between now and the 31st of the month. I can get any qualified for home care Medicaid financially because there's no look back. I just move stuff around. Community Medicaid is great for helping people age on their terms at home, and it kind of grows with them as their needs increase. So that way, we're able to stay in our own home and so on and so forth. Watch the webinar tomorrow. Now, as of now, sometime this year, they may implement a 2.5-year look back period for home care. We'll see if that happens. Again, we'll see. I've heard that story for 3 years now. Let's get back to trust though. It's a special kind of trust that allows us to qualify for Medicaid and protect our assets while avoiding probate, while leaving money to the right people, while you are still in control of everything. The trust we're talking about right now is a form of irrevocable trust. I write there, it's technically an irrevocable trust. And I got to write technically because people freak out. Brian, I'm going to pick on you again. I'm going to ask you, Brian, what does the word irrevocable mean to you? What do you think, Brian?
It can't be changed.
Can't be changed. What else? Do you lose control of something you do irrevocably?
Yeah.
All right. And just to be clear, you can't undo it because it's irrevocable, right? So you're wrong on everything, Brian, but only because I'm leading you that way. Most people think irrevocable means you can't change it, you can't undo it, and you don't control it. And those people are wrong because they're thinking of irrevocable, the word that we use day to day. They're not thinking of the legal definition of the word irrevocable. If I asked you guys to peruse a book, you would flip through it, right? You would skim a book. If I said peruse, you're just flipping through it. Yeah, I'm going to glance at it. But that's not what the word peruse means. Look it up. It means to read through carefully. But the way we use it in life is not what it actually means. Irrevocable is one of those things. It's taken on these characteristics like you can't change it. The only thing irrevocable means, and thank God we're not in person because people start throwing tomatoes at me when I say this. The only thing that irrevocable means is not revocable. Okay? We all agree there? Irrevocable means not revocable. Well, I think it's important to know what revocable means. We just spent some time talking about revocable trusts. What revocable means is if you create something, you by yourself with just your signature can take something out. When we do revocable trusts, the goal is avoiding probate and very little else. We're able to get into our trust. We're able to pull things out whenever we feel like it. We could blow it up tomorrow if we felt like it, but the key is it could be blown up by yourself. That's what makes it revocable. If irrevocable means not that, it has nothing to do with changing. Brian, you didn't hear me say anything about changing your trust as to who your beneficiaries are. Your revocable trust is amendable. Your irrevocable trust is amendable when it comes to changing your beneficiaries. You could change your trustee in an irrevocable trust. One has nothing to do with the other. Now, there are plenty of irrevocable trusts that may stop you from doing that, but that's just because that's how the trust was written. That's not how our trusts are written because it doesn't have to be. So in this kind of irrevocable trust, you can change it whenever you want to. It is amendable. You can change your beneficiaries or your trustees whenever you feel like it. In this trust, it's all for you during your life. There's nothing about irrevocable that says it can't be. So you are the income beneficiary of the trust. You put stocks in there, you're getting those dividends. You're getting them quarterly or however often you get dividends. If you want to take something out of the trust, it can be done. Well, wait a minute, it's irrevocable. Well, right, it still can be done. You just can't do it by yourself, because if you could do it by yourself, it would be revocable. Let me give you an analogy and we'll kind of move on here. So, Brian, looks like you're in your kitchen. Sorry, I keep picking on you. Do you have a toaster in there?
What's that?
You have a toaster in your kitchen?
Sure.
Thank you. For purposes of this example, can you move a toaster?
Yes.
Can you move it by yourself?
Yes.
It's movable.
Right.
Yeah. You could put it in your car and take it back to the store by yourself. It is something you could do by yourself. It is akin to a revocable trust because you could do everything by yourself. It's a toaster, for crying out loud, right? Do you have an oven?
Yes.
Can you move it?
With help.
Yeah, I was going to say, I picked the wrong guy. You look pretty big. A oven is movable. Absolutely. It can be moved. You could probably pull it out by yourself. You could probably drag it across the floor and ruin some nice wood floor or something like that. But if you were going to take it down the stairs and throw it in your car, you're going to need help, right? It is
Right.
accessible. You can get it out of there. You can get a new stove. You can get a new oven. It got there somehow. But we need help. Well, who do you need help from, Brian? I'll answer it for you. Anybody, whoever you want, whenever you want. You call me up, I'm not available, you pick somebody else out to help you remove something from your house. So an irrevocable trust can actually be undone. Stuff can be pulled out of it. You just can't do it by yourself. Okay, there's strict rules on how it happens, but you could actually get money out. Control. Well, you control everything, just like, you know, a puppet master controls the puppets, right? You got trustees and beneficiaries on a string, and they help you and do whatever you say. And if they don't, we go back to that power where you could remove them whenever you feel like it. So irrevocable gets a bad rap because people think about, oh my God, I can't change it. I don't control it. I can't undo it. I'm stuck. I can't believe you did an irrevocable trust. Are you crazy? No, you're proactive. You're doing the kind of trust that avoids probate, leaves money to the right people while protecting assets. Now, how and why does it protect? We talked about characteristics of it. I got to connect it. What Medicaid looks at when they see whether or not you qualify, they look at what assets are at your fingertips. What monies, what appliances can Brian move by himself? So right now, your toaster is something they care about. Right now, the house you guys are, if you don't have a trust, okay, the house you're in is a toaster, because right now you could sell that house to me if you wanted to. Your signature has that power. Okay. Your brokerage account is a toaster. Your bank accounts are a toaster. Everything that you can get to by yourself, with the exception of your retirement, is a toaster in Medicaid's eyes. They say, oh yeah, you can get to it. Your cash value and your life insurance, go sell your house. Go get that equity out of your life insurance. Use it on your nursing home before you come talking to us again, right? They're going to say, if you could touch it, touch it. That's why the revocable trust doesn't work. It's your signature does too much, right? I need toasters to turn into ovens. So we create this trust, we take your toaster, we put it into your trust. Now it's an oven, because in order to get this out, I need that help. I control who's going to help me. And that's how you control the trust. Now, it seems like a lot of work. Why in the world do you do this? Because nursing homes are $15,000, $16,000 a month. Because if we don't, we're going to private pay until we have very little left. Some attributes about this Medicaid trust. You're not the trustee. Someone else is. It could be your kids. You're the income beneficiary of the trust. Most people put their house in the trust. We start with that. Why? Well, because that's the thing that's going to go through probate if we didn't have a trust, right? A house is rather illiquid. Principal can be removed from the trust. However, it's under special circumstances in accordance with New York law. And, we're involving our trustee and so on, right? We're third parties that are going to help us move the oven. You can change that trustee, by the way. And after all, it's just a good old fashioned estate plan, says who gets what. If the trust has been funded for 5 years, those things that have been in there for 5 years, regardless of what they've grown to, will be exempt as a resource when it comes to a Medicaid application. They can't count it against you. Translation, there's more money preserved to move on to your kids and other generations or charities, whatever your estate plan is, because less of it was used to pay for your long-term care needs. I just spewed out a lot about Medicaid trust without going through a lot of slides. So I apologize for that. One really important thing I probably should have started with. The end of this webinar isn't that you've decided you need a Medicaid trust, right? Or that all you need is a will. The end should be, I need to learn more about it. I got to meet with an attorney that does nothing but this to figure out whether my fact pattern is appropriate. There's lots of loopholes in what I do. There's plenty of times people come in saying they want to do a trust and they leave without doing a trust because they didn't need it based on their fact pattern. So everything we're talking about now, it still needs to be applied to your facts. Some overall highlights between trusts and wills. Wills go through probate. Trusts don't. Probate costs money and it does delay the distribution of your assets. So I'm not spitting this. This is just reality. Okay. Trusts exist during your life. Wills take effect after probate, after you're gone. Trusts are really hard to contest. Wills are also really hard to win on a contest, but it's easier to contest a will, even though it's really hard to win. Sometimes the contesting part is the whole point. They just want to make the estate cost as much money as possible because they're so upset they got very little from the estate. Trusts are private, wills are not, estate administrations are not private. In fact, someone who had a probate or an administration because they didn't have a will, you can go to the county surrogates court and upload all the different forms that were filed about the value of their estate and other details of it. So it's very public. That's how you find out all this stuff about celebrities when there's articles about this, so-and-so celebrity just died and here's what their estate plan was. In terms of what's right for you, I have no idea. I don't even know you guys. Well, I mean, some of you I know, but most of you I don't. So you need to go see an attorney and talk about your goals and talk about your family and talk about your assets. And, I understand we're never going to go into a nursing home. No one ever is. Somehow they're always full. I don't get it. But let's come up with a plan to age in place. Let's go watch that webinar tomorrow at 2:00 to learn more about it. we have special circumstances with special needs in the family, or we have some, furry members of the family we want to take care of specifically in a certain way. These are all factors that go into, I think I got to go from a will to maybe a trust. Maybe I got to go from a revocable trust to a Medicaid trust. Maybe I got to do something else. A couple times where I really, 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 really want you to consider a trust. Obviously, just owning real estate, because that's something that's going to go through probate. I really don't like probate. We do so much of it, and it's really aggravating. I don't want to. No one works for surrogates court here, right? It's just there are rules, and sometimes the rules are lose the forest for the trees, and we're unnecessarily spending clients' money to jump through hoops that just don't seem like they make a lot of sense. If you have assets, specifically real estate in multiple states, absolutely we want to avoid probate because, for example, a lot of our clients have a little place in Florida. If they're going through probate, it's a New York probate to then do a ancillary probate in Florida. We're doubling expenses. We're hiring a Florida attorney. We're doing all sorts of extra work. If you have a business, you have to have a plan. Those plans usually involve trusts. I mentioned avoiding probate a bunch of times. If we're not leaving things equally to our kids and we're sensing that there's going to be a fight, please avoid probate. Just make things easy. So it's harder to contest. It's going to be hard to win anyway. Let's make it hard to contest itself. And then privacy. I mean, that doesn't speak to me all that much. I really don't care. But a lot of people out there want their affairs private, and I can understand it at least. Thank you for listening. I'll open it up to questions in a second. Just want to point out we do have a radio program Saturday mornings at 8 a.m. on the Magic 590, 100.5 FM stations, and then a little further north on 96.9 FM and 1410 AM. And then if you missed it, on Sundays, we replay that radio show in Ulster County and the Kingston market on 92.9 WBPM. Thanks for joining us. I'm just going to stop recording this for a moment, and then I'll open it up to questions.